Thank you for that introduction. I appreciate everybody coming here today, and I appreciate the fact that everybody is here and acknowledging what an important subject and topic this is. This is an important topic that is facing so many families across a broad spectrum. Lots of people are facing issues with regards to these sort of categories I've identified: substance abuse, mental illness, and special needs. So I think it's great that everybody has come out and shown an interest in this topic that continues to evolve. The increase in people with substance abuse issues, mental illness, and the diagnoses of special needs has really, and I've said this a couple times this morning, really altered the landscape of estate planning. As estate planners, we are used to the changes in laws and having to be flexible for that. But now we have moved to having to be cognizant of changes in society and changes in social norms and what's happening out there, and how people and different issues that are affecting people, and how we have to plan for that. And we really have to take that into consideration. In the past, the focus for estate planners oftentimes was minimization of taxes, avoidance of probate, and more of those objective, what I would call black and white issues. Now it's to the point where we have to look holistically when a client comes into our office, and we have to really pull on that title of counselor at law. Not counselor, I know there are some counselors actually in the audience, but not counselors where we are advising people on how to deal with special needs or mental illness, but instead counseling them on how we are going to handle it on their estate plan, and recognizing these issues. And we have to do it in a way that is compassionate, because this is regarding people's lives and their family. So there's also, you have to be very cognizant of what's happening, and you have to have compassion in your estate planning in order to be effective for your clients. While the development of an estate plan can be difficult for any family, of course, families with any of these issues, it presents additional complexities. The thoughts that are running through your client's mind when they walk into your office are several different thoughts running through their minds. But for clients with these unique beneficiaries, as I call them, and I don't want to call them challenge beneficiaries, they're unique beneficiaries. The thoughts that are running, there's this running dialogue in their minds. Who is going to care for my loved one? Who is going to manage the assets? Will there be enough assets? How are things going to be paid for? How is this going to impact other family members? There is this dialogue that is just running over and over in their heads, and we have to be able to address all of that. The process for developing an estate plan for these unique beneficiaries typically requires more than just simply drafting documents. It requires the ability to navigate through the confusing rules of government eligibility, and I cannot stress that enough. The confusing rules of government eligibility that are changing all of the time. The current laws, you have to navigate through medical issues and other topics that are affecting your family. So you really have to think, again, I like that word, holistically. You have to think holistically about your client's estate plans. What we're going to talk about today, we're going to touch on some various different topics. In the interest of time and for what this is, we're not going to be able to dive into every single point. So there's going to be several trusts that I'm going to talk about. There are a lot of provisions and points within those trusts that we just simply don't have the time to get to. But I want to give you an idea of the options that are out there, the various different options that you have for your clients, your loved ones, yourselves. Because of the subject matter too, and it is a sensitive subject matter, there likely will be questions. You will likely have a lot of questions. I am happy certainly to address any general questions, but also to talk privately with anyone afterwards. I'm happy to hang back and address your concerns via in-person, email, or phone, because there will probably be several. So now let's get into the details. For purposes of this breakfast briefing, I have focused on 3 different types of categories or groups of individuals. And while I'm going to attempt to define them and sort of separate them, we have to realize that they are intertwined. They are very, very much intertwined. Mental illness is one that is usually an underlying issue under most substance abuse issues, special needs. So even though I'm sort of separating them into categories, we know that they are all completely intertwined. So let's begin. So special needs, I thought this was a good definition. Various difficulties such as a physical, emotional, behavioral, or learning disability impairment that cause an individual to require additional or specialized services or accommodations, such as in education or recreation. I've broken it down a little bit. When we're talking about physical, of course, we're talking about muscular dystrophy, multiple sclerosis, chronic asthma, epilepsy, cancer, any sort of physical ailments. Developmental, when we talk about developmental, we're thinking about things like Down syndrome, autism, dyslexia, processing disorders. For behavioral emotional, we're talking about things like ADD, bipolar disorder, oppositional defiance disorder, and the like. And for sensory impaired, certainly that blind, visually impaired, deaf, limited hearing. So those are some of the categories that we're talking about when we refer to special needs. Mental illness, of course, are disorders that affect your mood, thinking, and behavior. Examples of mental illness include depression, anxiety disorders, schizophrenia, eating disorders, bipolar disorder, and addictive behaviors. That's basically how they would categorize mental illness. 5.1% of adults have serious mental illness in Ohio. I thought that was an interesting statistic, and nearly 460,000 Ohioans suffer from a serious form of mental illness. As for substance abuse, certainly substance abuse, and I didn't necessarily define it here. I think we all know what that is. We're talking in Ohio, the substance abuse is not only alcohol, and sort of the illicit drugs, cocaine, heroin, marijuana, those remain the most commonly illicit drugs. But we're talking about addiction to painkillers, right? I'm sure we've all heard, known, likely even know somebody who, pops Percocet daily and is addicted to Vicodin. Those types of things, that is also a drug addiction. And it continues to be on the rise in Ohio. So the CDC ranks Ohio among the top 5 in terms of residents suffering from various drug or alcohol addictions. That is not a statistic that we should be proud of. If you have turned on the news at any point in the recent past, you've probably seen the overdoses, particularly the heroin epidemic in Ohio has truthfully gotten some out of control. We have courts that are addressing it. We've got drug courts. We have a lot of community services coming together to address it because it is so bad in Ohio. Nearly 700,000 Ohio residents aged 12 and up abuse illegal or legal substances each year. And nearly 20% of adults admit to binge drinking. Alcoholism, because we consider it more of a social norm, we forget that it is too an addiction that several people suffer from. So, and Ohio is ranked 2nd in the nation for the number of overdose deaths in 2016. Again, not a statistic that we are happy about. So, while we're here to talk about the planning and how you would plan for these unique beneficiaries at your death, we also have to recognize that there are certain things you can and should consider doing during your lifetime. And I called this slide Gaining Control Over the Adult Beneficiary, but it's things that should be considered while you are here, things that you will actually be able to see put to use. So we put together an estate plan. We hope we put together an appropriate plan, and we hope that it gets administered the way that we want. But ultimately, at the end of the day, we are not here to see how it plays out. These are the types of things that you can do during your lifetime. And for this, I'm talking about the actual beneficiary, so the actual child. Let's call it a child who has either special needs or substance abuse issues. If they are legally competent enough to execute documents, you should consider having them execute a healthcare power of attorney. These types of documents can be executed during any time that there is lucidity. So even if you suffer from these issues and a person has periods of mania, let's say if they have bipolar disorder or severe depression episodes, there are also other times when they can execute in these documents. And truthfully, you should do that anytime a child even turns 19, 18, and is going off to college, right? A lot of the colleges will make them execute a healthcare power of attorney, but that is something that we should do with any adult beneficiary, and that's an important thing to do. And the healthcare power of attorney, in case we're unaware of what that is the document that allows you to name an agent to make healthcare decisions for you in the event that you are incapacitated. So this is important because simply because you are a parent to somebody does not give you the right to walk into the emergency room and make healthcare decisions if this person is over 18. By having this document, it will give you that right. If the individual has an opinion and a wish regarding their end-of-life decisions, that's where the living will steps in. So if this person knows that they don't want to be on life support or hydration or nutrition, then they should consider executing a living will. That's something that you should talk to them about so that those decisions are made for them. And the HIPAA release. I had a client not so long ago tell me that the HIPAA release for an adult beneficiary of theirs who had substance abuse and was in and out of treatment was the single most valuable document I put together for them. Now, I had done several documents, and as an estate planner, I looked at the complexity of some of these other documents and was pretty proud of them. And to have the client come back and say, that 2-page HIPAA release, that is the most valuable thing you ever gave me. And that was where we had the adult child execute a HIPAA release. And for anybody who doesn't know what that is the document that allows you to get medically protected information. So certainly medical information is not available to anyone unless they are authorized to receive that for adults. And so for children, particularly substance abuse, where we have to get them in and out of treatment. They're in treatment and we need to talk with the doctors. We need to help them in their recovery. Having this document to be able to step in and help them is very valuable. As for the financial documents, we also have the durable general power of attorney. Excuse me. And the durable general power of attorney is the document that allows somebody to make financial decisions. So that is also important when you have beneficiaries who have some of these issues. You want to be able to help them with their finances, be able to have access to their money if necessary to help them during times when maybe they are unable to help themselves. And I always say with adult beneficiaries that are unique, make sure you're reviewing the ownership of their assets, helping them review beneficiary designations, and essentially putting their estate plan into place. Maybe there is a goal of avoiding probate for your adult child's estate plan. You don't want to be stuck in probate administering their bank accounts or their car if they have it or whatnot. So if they are well enough to execute a last will and testament, those documents would be very valuable as well. And those are things, again, you can do during your lifetime. Guardianship is the other option if your adult beneficiaries are unable to care for themselves. And that's when you're noticing that they're unable to make financial decisions or medical decisions. Oftentimes the doctors will be the ones to tell you that somebody should consider getting guardianship. There are different types of guardians. There's the guardian of the person, which is related to medical and residential decision-making only. And there's the guardian of the estate, which is somebody who is managing the ward's finances. You can have a guardianship that covers both. Oftentimes they do. But that is something that may be a way that you can help your adult beneficiaries if a medical doctor or, truthfully, a licensed social worker says that a guardianship is necessary. The only one that can make that determination is the probate court. So even if you have an expert evaluation and you have a doctor that says this person needs a guardianship, you still have to go through the process of having the court declare them incompetent in putting together the guardianship. The other thing that I didn't put on here is a conservatorship. That's another option, and a conservatorship is for an individual who is physically infirm but unable to handle their finances. And they participate in more of the appointment of the conservator and things, so that the guardian or the ward in that case has more of a decision-making authority on that. So those are some things that you can do and you should consider getting in place. Yes?
If you have guardian of person, do you still need the health care power of attorney as far as medical decisions go for that person?
So technically, no. So what happens with the probate court is that the probate court, before appointing a guardian, is always going to look at the least restrictive means. So if a person has a healthcare power of attorney and somebody has a HIPAA, well, part of the healthcare power of attorney is the HIPAA release, but if they have that, then the court may not think that a guardian of the person is necessary because you already have those, those abilities. But so yes, if you don't have it, then of course the guardian of the person may be necessary. But oftentimes there are other reasons that you would need a guardianship as well, typically to manage the ward's estate and things like that, although a power of attorney would give you that. So court always looks, because a guardianship is essentially taking away that person's rights, and it's a very big decision, and it needs to be evaluated by the court. And the court is always required to do least restrictive. So this is for the more serious of the cases. So when we have these special needs beneficiaries, the parents' concerns, and this is a small list of the parents' concerns because this list can go on and on, but these are the ones that the parents rattle off as soon as they sit in my office, and that is quality of life, including the residential placement, the medical care, the social activities. Who is going to care for this person the way that the parent has? And of course, that is the number one decision or concern that parents have. Certainly the financial security and management of the assets. Likely these individuals are unable to make good financial decisions or manage their assets properly. So who are we going to trust to put in place and do that? Potential exploitation by others. I hate to even say this, but individuals in these three sort of categories that I've been talking about are at risk for exploitation. A lot of people prey on them for get-rich schemes, and they want to take advantage of them for any number of different reasons. So potential exploitation by others is a serious issue. Burdens on the other children. This is the other one that tends to be, truthfully, the most emotional. And my clients have a really hard time with this because they're concerned about, after their passing, how is this going to affect that child's siblings or the other family members and I hate to say that burdens because we're talking about typically loved ones and whatnot, but how is it going to affect the other children? And that is a huge concern for parents, rightly so, of course. And last is the eligibility for government benefits, which we are really going to dive into in the next few slides. But the eligibility for government benefits is very important. So with regards to, and we'll get into that, what I'm talking about when I'm talking about types of benefits and why that's such a huge concern. So how do we manage these concerns? The quality of life. That can be managed by the selection of appropriate caretakers. Who is going to be the one that's going to look after this person, both personally and financially? And so in your last will and testament and your power of attorney, if you have it drafted as such, you can nominate people to be guardians. If you are the guardian of an adult beneficiary, you can nominate someone to step into your place. Again, that is only a determination that can be made by a court, but you can give the court insight as to who you trust to step into this position. So selection of caretakers is very important. I put on here preparing a statement of wishes. People call it a lot of different things. They may call it a letter of intent, or I've seen it called a number of different things. But a statement of wishes for the caregivers is a non-binding legal document. It's not binding in any way. It's sort of what I would say is similar to our personal property memorandum, where it's not part of our will, but we use it sometimes to give direction. It's basically giving direction to caretakers. This is important. I've seen clients use it, and I've seen clients really, or I've seen the caretakers really use it, and it's become very useful. And it's basically just writing down the things that someone needs to know about this individual, the doctors they prefer, the issues that they have that might not be readily available from a medical record, or that people might not know. If you're appointing your sibling maybe to take care of a child, they don't live with this person, so maybe they don't know some of the important issues, the things the person likes, the therapies that are important to this person. So it can be any number of things. I mean, certainly that list can go on and on and on. But preparing that, if you have a child or a beneficiary of special needs, can become very useful. Financial security. This is, so where the other slide we were talking about things that the actual beneficiary should execute. Now, this is the parent's concern. So proper financial planning for parents is a very important part of this, okay? So reviewing and working with a qualified financial planner to ensure your own financial security. I use the example to describe this as, you know, when you're in the plane and they come on the loudspeaker and tell you put on your oxygen mask before you put the oxygen mask on the person sitting next to you. Why do they do that? You need to be secure before you can help somebody. So when we're talking about passing assets on or caring for somebody and making sure that they're properly taken care of after you're gone, you have to make sure that you're doing what you need to do to be able to help them. So I tell parents, evaluate that. Evaluate the life insurance. Life insurance tends to be one of the things that funds most of these trusts at your death. That's a large sum of money that's coming in at your death. So for people with these unique beneficiaries, making sure you're properly insured and that there's going to be those funds, and again, we'll talk about what to do with those funds and how to use them so they don't affect eligibility for benefits, but being properly insured and having enough assets to help that loved one is an important part. And again, the eligibility for benefits. So the establishment of various different special needs trusts to make sure that they are taken care of. There's really 4 main trusts, and it's funny because in the world of special needs, people call these trusts various different things. And I know there's some planners in the audience right now. And so this is what I call them because I think that this is how they are easy to understand. A Medicaid payback trust is also called a D4A trust. That's a very technical name for a trust, but you will see that. And we're going to talk about what each of these are. And then there's a supplemental services trust, a pooled trust, and a discretionary third-party special needs trust, a supplemental trust. It's called a bunch of different things. So before we talk about how we're going to preserve the benefits, let's talk about what benefits am I talking about for the people that may be unaware of that. So what is Medicaid? Medicaid is a jointly funded federal state health insurance program for low-income and needy people. It is a needs-based program that pays for services for the elderly, blind, or disabled. It is needs-based because their income and asset limits. So when people, and I had somebody in my office the other day who said, a very wealthy individual who said, well, I'm going to have enough money to be able to pay for anything for my child, so why do I even need to worry about preserving benefits? I don't even know if my child's going to have benefits. Well, the idea is that Medicaid covers medical expenses, prescription costs, in-home health care services, long-term care, and certain services, depending on what the special needs are. There are various different services out there that may be right for your child. They may be part of different programs depending on where they fall, and they may be eligible for those because of that. And those may be good. They may enhance their quality of life. And so the other thing that's important is many of our county boards of developmental disabilities in Ohio have begun charging for services if the Medicaid if the person is not Medicaid eligible. And the County Board of Developmental Disabilities has good services out there for people with special needs that they may want to take part in. So it can be good for people. So let's talk about some of the special needs trusts. Let's dive into those a little bit more. And this is where, again, I'm an attorney, so I'm going to have a disclaimer, right? We all have to have a disclaimer before we say anything. The disclaimer is these are not exhaustive lists about these individual trusts. There are several other required provisions, different aspects of these trusts that, in the interest of time, we're not going to dive into them. The idea for today is for you to understand the general differences among them and to have an awareness that they exist, to see if they are something that either you or someone you know may benefit from. So the first one is the Medicaid Payback Trust, again called the D4A Trust. Also, this is a trust that sometimes people just generally refer to as a special needs trust. This is something that is created by a parent, grandparent, guardian, or court. It is established with the funds belonging to the beneficiary. They must be the funds belonging to the beneficiary. They can also be funds of a third party, like a parent or whatnot. For this type of trust, the beneficiary must be under 65 years old and have a disability as identified under the statute. This type of trust, as it's called, a payback trust, must include a payback provision. When I refer to a payback provision, I'm talking that the state will be reimbursed for the total amount of medical assistance paid on behalf of the beneficiary. And the trustee is authorized only to pay for supplemental needs over and above what the government, what Medicaid is covering. The issue with these trusts is that you don't want to overfund them, right? There's a Medicaid payback provision. So any assets that are in there are going to be paid back to Medicaid. So you want to be careful about overfunding this type of trust. Okay, so the next type of trust is a supplemental services trust. This must be created by a third party with third party funds. So this is not the money of the let's call it the beneficiary. The beneficiary must qualify for services through the Ohio Department of Mental Retardation, the County Board of Mental Retardation and Developmental Disabilities, the Ohio Department of Mental Health, or a Board of Alcohol, Drug Addiction, and Mental Services. The maximum principal contribution in 2018 that can be put into this type of trust is $248,000. Again, the distributions must only be for supplemental services, so it can't be for general welfare, comfort, food, that sort of thing. It has to be for anything over that. So Medicaid will cover all of those general care needs, and this is for things over and above that. At the beneficiary's death, 50% of the remaining balance must be paid back to the state. That can be a lot of money. I was just speaking with another person in the audience and who practices in this area. I don't use special supplemental services trusts very much. It's not my favorite vehicle for my families. Pooled trusts. Pooled trusts may be established by a parent, grandparent, guardian, court, or the individual. So this could be a case where an individual has an inheritance, a personal injury settlement, money that they had from maybe working, if they're able to earn a little bit of money. Because again, just because you have special needs doesn't necessarily mean that you can't get out and earn a small sum of money. So There's no age limit on this one, so which is unlike the others. It is managed by a nonprofit organization and consists of a master trust and subtrust. So that is the part of this that is different. Is basically the management is collective, and the assets are pooled together for the purposes of investment, and so they're pooled together with other individuals that are similarly situated. That's why it's called a pooled trust. So a separate subaccount is maintained for each beneficiary, but the assets are pooled for investment and management service purposes. It is, we say, well-suited for circumstances where the assets are small, but it's also well-suited for people who don't have a trustee, people who don't have somebody that can step in and help them, so that it's managed by a nonprofit. At the beneficiary's death, an amount that does not exceed the total amount Medicaid paid on the beneficiary's behalf and that is not retained by the trust must be paid to the estate. These trusts are nice. They're good. I've used them before, and there's a company in Cleveland called Community Fund Management that is terrific. They are absolutely terrific. They handle pooled trusts, and they are a nonprofit. Their website is very good if you want to learn more about pooled trusts, and particularly them. There are other organizations in Ohio, and I have no affiliation with Community Fund Management other than I've used them. They're wonderful. The people, when you call, are great to work with. Their documents are well done when you actually take a look at their master trust document. The trustees, because they are the trustees who manage the money, I think they do a terrific job. I really can't say enough about them. And then we have discretionary trusts, sometimes called supplemental needs trusts. These are created by a third party with the funds belonging to a third party. The trustee has absolute discretion in determining the asset distribution. And there is no, this is the important part, I can't highlight this enough, there is no state payback required because these are not the individual's funds. These are funds that go into this trust that hopefully, well, in order for it to work, never touch the beneficiary's hands, right? Mom and dad put their money into this trust for the benefit of their special needs beneficiary. So Medicaid does not need to get paid back for this. So if you're gonna fund a trust, if you're gonna overfund a trust, this is the one that you wanna do. This is where you wanna put your money. In order for it, and again, there are so many provisions with regards to these trusts that need to be incorporated for it to be valid under Ohio, and I'm not going to get into the devil's in the details, so I'm not going to get into all the details about them, but it must include and it will often include a poison pill provision, which is a clear statement that requires the trustee to terminate the trust if it is counted as an available resource, and that's important. This is the type of trust that I use mostly. This is the one that I've administered the most and the one that we have the most success with. I'm going to talk about a stable account briefly. A stable account it allows a single tax-free investment account to be established for individuals who were disabled before the age of 26. Annual deposits cannot exceed $15,000. The deposits can be from anyone. And earnings in the stable account are not subject to federal income tax as long as the funds are spent on qualified disability expenses. And examples of those include education, housing, transportation, health, prevention, and wellness. And this is a federal, it's a federal, it came out of the ABLE legislation. So something to consider, something to think about, and a way to help your special needs beneficiaries in a way that that they can also, again, a place where they can put their own money. If in fact you might not want to put together a special needs trust, or it might not be necessary, a stable account is a way to help them with their money. Those were what we do for special needs. And for those individuals, those are individuals who qualify and are considered disabled. Those are the things that you need to do to maintain the eligibility for their benefits. I'm going to turn a little bit right now to the impact that substance abuse is having on wealth planning. We've talked about it a little bit. I introduced a little bit at the beginning. I thought these were startling statistics. 142 Americans die every day from a drug overdose. That's a lot. As many as 650,000 people will die over the next 10 years. In 2018 so far, there have been at least 137 suspected opioid-related deaths. I think that number might actually be a little larger than that. When I had gotten that statistic, I don't know if it was necessarily in June. So this, I suspect that number is much larger, and it is on the rise. Ohio is one of the hardest hit states in the nation by the opioid epidemic. In fact, there was an article in the newspaper not too long ago that went through it and following families who have been affected by it. It's quite startling. Beneficiaries with substance abuse. So beneficiaries with substance abuse don't always fall into the categories that we just talked about in terms of disability and special needs. But what do you do with these types of individuals? If you got the email, which you probably did, the title, when we talked about it, we said writing a blank check to a child with substance abuse issues can cause disastrous outcomes. So what do we do? Before we talk about maybe what we should do, let's talk about the common mistakes that I see all the time. The natural reaction for someone is, well, we're just going to disinherit them. We're just not going to give anything to that beneficiary, and we're just going to take them out of the will, take them out of the trust, and not deal with it. That's an emotionally difficult thing for parents to do. And sometimes when the parents come into my office and talk about doing that, you can tell, the tears are flowing sometimes, and you can tell that this is not really what they want to do, but they're at a loss and they don't know what to do. This may create tension among family members. You have an individual that was disinherited, and his or her siblings have just inherited a lot of money, and so now they feel alienated, they feel upset. They've just lost a parent, and now they have emotional issues with regards to how that parent thought about them, that they disinherited them. And their reasons for disinheriting may not be for lack of love or affection, but because this person has a problem. And so from a psychological, and I'm not a psychologist, I know what I know and I know what I don't know, but from a psychological standpoint, I think to think about how that would affect a person who already has substance abuse issues, likely underlying mental illness with the substance abuse, and now to have been disinherited by mom or dad at their death can cause a spiral of issues. Furthermore, the addicted beneficiary may actually need those funds. They may need them for recovery, for medical expenses. And so disinheritance, in my opinion, unless you have other reasons that you want to disinherit this person, disinheritance is not always the best option. And one that I typically I don't discourage, but I try to explain so that they make sure that they understand it. Outright gifts. This is the one with the blank check. So outright gifts are, there's a potential for money to be squandered, of course. Sometimes these individuals, unique beneficiaries, do not make the best decisions. So of course, writing them a blank check for a lot of money is a risky thing. You can unknowingly be contributing to the beneficiary's unhealthy or risky lifestyle. If you have a drug addiction and you just gave them a blank check, it probably is not going to end well. Oftentimes, and I put this on there because I've seen it, the influx of suddenly I have money to pay for the drugs that I was trying to step away from is triggering a relapse. And so we certainly wouldn't want anything. Mom or dad, that's the last thing mom or dad would want, is that their death has actually triggered a relapse for someone. And certainly putting a beneficiary at risk for being exploited by others. Certainly, that's sort of self-explanatory, but that's what these outright gifts, so outright gifts might not always be the best option as well. A lot of times people come in and they say, well, I'm just going to give it to their siblings. Sally's going to take care of John. She loves him. She's always been a mother to him. She's just going to handle it. So I'm going to leave my entire estate to his sister, and she can handle it. Certainly, once you do that, you have the inability to control at your death how those assets are spent. Sally may be telling you she's going to spend it and use that money on her brother John, but she may not, and there is no legal obligation for her to do that. Assets are owned by the family member, and that means they are subject to that person's spouse, creditors, liability. They're part of their estate. So they are subject to anything that, any of the liability for that person. So that may not be the best thing. That person, once they accept it, that person it can potentially have creditors come after it or any number of things. In the event that the family member dies, the assets become part of his or her estate. Certainly, Sally can tell you, well, in my will, I'm going to make sure that I leave it to someone to handle for my brother or whatnot, but we have no way to know if that's going to happen. And really, from just a personal standpoint, unfairly putting that family member in an uncomfortable position, having to deal with the addict beneficiary. Your sister handles the money, and so now the addict's knocking on the door at 3 a.m. in the morning because they want their money that mom and dad left us. So gifts to other family members, I consider that a mistake in planning unless there is a compelling reason why we need to do that. So these are what I would consider not the best plans. Beneficiaries with substance abuse types of trusts available. Let's talk about that. So what can we do? Well, we can do a trust with staggered distributions. This is more of the type of trust that we do with individuals who have beneficiaries that do not have special needs. And these are where we distributions are spread out over a period of years. So you may say, as the beneficiary reaches certain ages, he or she is entitled to various different distributions. At age 23, they're going to start getting income quarterly. At age 25, they're going to continue getting income, and we're going to add half of the principal. At 30, we're going to add, continue getting income distributions and the balance of the what's in the trust. That's fine. That can certainly span a few years and maybe give the beneficiary the opportunity to get older and more mature and get their life together and be able to handle that money. And so for families with beneficiaries who aren't facing these issues, that's a common plan and that works very well. But if we're talking about these subset of the population with beneficiaries who have these issues, you're still giving them large sums of money. You may be doing it at different years, but they're still having full control over this money. Ensures that the beneficiary doesn't receive everything at once, but again, they do get these distributions. And we do usually say that the trustee discretion is often included, so the trustee has discretion. But my concern with this one is that the beneficiary eventually receives sums of money and has full authority over those sums once they receive it. So for people with severe issues, substance abuse, mental illness, that sort of thing, trust with staggered distributions is not always the best opportunity either. We can work with it, but it's not always the best. Incentive trusts, there was a big push at one point for people to start doing incentive trusts, and incentive trusts are pretty much what they sound like. Distributions are only made upon the occurrence of certain milestones. You graduate from college, you're going to get your distribution. You are gainfully employed, you're going to get your distribution. It is used to encourage positive behavior and limit undesirable behavior. It's a way that people can promote certain ideals and reward beneficiaries for acting in ways that the grantor would want them to act. Problem with this is that there's first possible resentment by the beneficiary that mom or dad is making me do certain things with my life that maybe I didn't otherwise want to do. May set unrealistic goals. And the number one reason, truthfully, is the change of circumstances may frustrate the purpose of the trust. This person may not go to college. Perhaps they have a learning disability that they didn't discover until after mom and dad had passed or after mom and dad had put this trust together and they didn't change it. And so getting a college education is not in this person's best interest. It's not something that they can do. And so now suddenly their distribution in mom or dad's trust is tied to this unrealistic goal that they can't set. So how do we handle that? So for those reasons, while it was a nice idea, I don't necessarily think that they administer well. The administration of them, I don't believe, is always the greatest. Wholly discretionary trusts, that I think is where we should be, and where this group should consider. So this is where the trustee maintains sole discretion over distributions of income and principal. Trustee is solely the financial gatekeeper. The beneficiary has no ability to force distribution, and the trust is not an asset of the beneficiaries, therefore is not subject to the creditors of the beneficiary. This is a type of trust that, I don't know for anybody else out here that plans, this is a nice trust to use. This one is the one that you can control from beyond the grave. Now, this type of trust can include the provisions to allow the person to still be eligible for Medicaid benefits. So this is, what we were talking about before. If necessary, we can add those provisions and sort of put everything in this trust. But this is a wholly discretionary trust. It does not give the beneficiary the power. It gives the trustee the power. Now, I didn't put on here, but there's concerns with everything, of course. And so we have to name the right trustee. And the selection of the trustee, while I didn't necessarily put a slide, the selection of the trustee is huge. We need to make sure, if you have beneficiaries with these particular issues, sometimes maybe a family member is good because they are intimately involved with this person's lifestyle. Sometimes it's bad because they're intimately involved with this person's lifestyle. So we have to decide whether or not a corporate trustee, there's pros and cons for doing corporate trustees. There's pros and cons for choosing different trustees. And so that's one of the things that we have to analyze with our families is who is the appropriate trustee, particularly when we're doing this because we're giving them quite a bit of distribution or discretion. So that's sort of touching on all of it. And this is my favorite quote as it relates to my job, not necessarily my favorite quote. And a goal without a plan is just a wish. I cannot help you administer wishes. I am not a genie. I cannot grant wishes. I can't do any of that. But I can help you execute a plan. I can do a plan. I can help you with that. So, and your trustees and your trusted loved ones, they can execute plans. They can't do anything if you just leave it as a wish. So, looking at these issues, being aware of these issues, being cognizant of them, and taking the time to address any of them is so important. As estate planners, I hope that everybody in my position is looking holistically at these. I hope that people are being compassionate and recognizing that we are not just dealing with people's money or assets, but that we're dealing with people's lives and their legacy. That's huge. My father always told me when you pass away, you don't take your money, you don't take your possessions, you take your reputation and the legacy of the people that you leave behind. And so that's huge. So that's it. In an interest of time, I think I actually got everything in, and according to my calculations, it's 8:57. Not calculations. So thank you. Thank you.